All right, everybody. Thank you so much for joining us this morning for our now third session of our campus chats and coffee. I, as always, am your host, Bridget Kessner from the Connecticut Alliance to End Sexual Violence. I am here this morning with actually mixing it up. I was enjoying the spring weather, and my partner made me a nice little iced coffee here. So I'm enjoying a nice iced coffee with oat milk from a little cup from one of my favorite breweries. So that's what I'm up to this morning. So thank you so much for joining us as we talk about enforcing student rights. So essentially, what do we do as students, as activists and advocates, if we find that students are in a position where they feel as if their rights need further enforcement through Title IX or through an investigations process of some sort, right? If they feel as if they need further recourse. So that's what we're going to be talking about today. So there are a few different mechanisms that students may have access to if they need to sort of seek this recourse. Some institutions have their own procedures that can be followed, so it's always good to check in with the student conduct handbook or something of that nature to see what different institutions have to offer. Sometimes they have sort of their own internal grievance procedure to process cases where a student may feel as if there was a sort of error in their case that impacted the outcome in addition to the appeals process. But speaking of which, a student also will always have information about an appeals process if they feel as if through a Title IX hearing, there were certain rights that were not protected adequately, or there's new information that may impact their case. So when that happens, they can go through that appeals process potentially. So that's something we're going to be talking about. And then additionally, there is the potential for an OCR investigation, which we're going to be talking about quite a bit further in the presentation. So starting with the appeals process, there are certain rights in appeals and to appeals that we will find that survivors have. So first of all, they're going to, under their Title IX rights, receive a written determination of their case. So after there is an investigation, they're going to hear back from the institution to say whether there was a finding of responsibility or not to the respondent, so the person who had harmed them. And both of those students or individuals are going to have a certain right to appeal the case on a certain basis. And there's going to be an explanation of what those bases look like, as well as what next steps they would need to take in order to put in an appeal. So that's always a written determination that they should be receiving. There also should be a documented process at all institutions of what these appeals should look like. So similarly to as you see a Title IX process laid out, in writing, there should also be a documented process to an appeal. Additionally, this appeals process should be reasonably prompt in the same way that we know a Title IX hearing should go. So it should be initiated and, be ongoing and completed in a prompt fashion. It should be ongoing. And the only time there should be delays are if they are both short-term and for good cause. So for instance, an example of a short-term good cause delay may be if there was an individual who had a disability that needed accommodation. So in order to accommodate the disability, they needed to ensure that the student could, retain access to the process. And so they let them know that that was the reasoning and that it would resume within, say, a couple of weeks, right? This is not something that should be left ongoing without a follow-up timeframe. And again, should only occur, any delay should only occur due to a good cause. So what are different grounds for appeals? First, definitely some sort of procedural irregularity. So if there is something, within that institution's own grievance procedure guidelines or within the mandates under Title IX that wasn't adequately followed, then that's something that a student could appeal and say that procedure wasn't followed, and therefore they want to appeal the case because that somehow impacted the outcome potentially. Also, newly discovered evidence is a reason to appeal if that evidence was so substantial that it would impact the outcome potentially. And then if there was some sort of personnel conflict where there was a level of interest or bias in the case that one of the staff members involved in it may have had, that again impacted the outcome of the case potentially. And that's what we're really looking at is when it comes to appeal, and there's these different reasonings for it, it does need to essentially impact the outcome of the matter potentially, and that's essentially what the student needs to argue. So one of these things could potentially occur, say there could be new evidence, but the student would need to argue that evidence, that has been heard would actually impact the outcome of that case in one direction or another. There are also additional reasons that an institution can add for appeals. This is just essentially what the federal government has sort of outlined as the reasoning within their own Title IX regulations. But there could be additional bases that the institutions add for students to appeal that would be documented in, again, because this process does need to be documented, would be documented in their own guidelines. So then another kind of route that institutions can sort of be held responsible under is the Office for Civil Rights. The Office for Civil Rights is responsible for enforcing civil rights laws that prohibit discrimination at institutions that are receiving federal dollars. This can include other types of discrimination, of course, and other issues of access to education, things like, ability discrimination around race. However, we're of course talking about it in its application to right of equal access to education to a victim or survivor of an issue of sexual misconduct. So that is sort of the, while it does have kind of this broader reach, that's the application that we're going to be talking about. So OCR can investigate a variety of different procedural issues and things of that nature, different rights that survivors have that institutions may not necessarily be following up with. So we're just going to be talking about some of the common ones. However, OCR can investigate really whenever there was some violation of Title IX, Title IX's regulation. So something that we'll see OCR investigate is whether or not necessary notices were received. So if a student who you're advocating for, or if you are a student, if there is a feeling that they were not notified of the proceeding initiating in a timely manner, if it was not something that upon the case ending they were notified of, right, with the ultimate disposition of the case, as well as options to appeal. If these notices didn't go out, then that's something OCR can look into. OCR can also investigate staff standards. So if somebody feels as if perhaps the process was not trauma informed by necessary staff training standards, if the individuals were not competent to be facilitating this based on lack of training, there are different staff standards, not only in our state law where it's more prescriptive, but also in our federal law that individuals need to be held to if they're going to be engaging in these investigations. So that's something that they can look into as well. There needs to be a publication and provision of a grievance procedure. So if a student does file, a formal complaint with the institution, they should be provided with a detailed sort of explanation of this grievance procedure. However, this is also something that needs to be published and accessible to all individuals at that institution. So they need to ensure that it is up to date and published. They also need to investigate whether or not the entire hostile environment was addressed. So the institution not only needs to address the issue at hand between, potentially these two parties, but also what was ongoing at the institution that potentially allowed this to occur in the first place, and how can we ensure that it doesn't continue to occur. Additionally, how can we ensure that there is not essentially an ongoing hostile environment that is harmful to that student. So say there is a certain department that, it comes up during the case has essentially had sort of issues with sexual harassment. How can we ensure that that department is being addressed? And how can we ensure that not only that harm doesn't occur again, but also the student isn't retaliated against in that space, and they still can retain access to that space after being involved in this report. OCR can also investigate issues around advisor. So students have a right to have the advisor of their choice involved. So that implies that choice was given. So students should not be told that they shouldn't have an advocate involved in their case, that they shouldn't have an attorney involved in their case. These are parties that are appropriately can be advisors in these cases. So the student should be able to choose that person if they would like to. Additionally, they, of course, should always be given a choice of advisor and not be told who their advisor is going to be. The institution also needs to provide them with an advisor if they do not feel as if they know a certain party that they wish to be. So if they give them an option of different advisors and the student does want an advisor but is unsure of who, the institution would be responsible of ensuring they have somebody competent that they can assign to that case for that student. OCR also very frequently investigates the promptness of investigations, and that's something that is really critical. So again, these investigations need to be initiated, be continued, and be concluding in a prompt fashion. So what they're going to be looking at is, again, what were the delays, how long were those delays, and was that timing really necessary? And were those delays with good reason? So again, was it to ensure that accommodations were made so that students had access to it? Was it to facilitate the investigation behind the scenes, the information gathering that the institution needed to do? But say providing it on a complete halt until the conclusion of a criminal investigation without an explanation as to why a criminal investigation impeded on that institution's investigation. That may not be an adequate reason for that delay, right, in and of itself. And so they really need to look into the promptness of that in many cases. And so that's something we'll see OCR look into. The equitability of the process is also something that they need to investigate. So were both students involved, or both individuals or parties involved, provided with, different protections, access to accommodations, things of that nature through that process, or was the, say the survivor really burdened in a way that was not equitable? They also can investigate the standard of evidence that was used to ensure that it was adequate based on the federal guidelines. So for instance, here in Connecticut, we use the preponderance of evidence standard, which is essentially just more likely than not, right? So it's 51% or 50.1%, more likely than not in one direction or the other in a finding of responsibility or not. However, when it comes to larger, federally, what institutions need to do is be applying the same standard to all different cases that hold the same disciplinary sanctions. So if, say, sexual violence is something that can make someone eligible for expulsion, and so is an instance of racialized violence, then both of those cases would need to utilize the same standard of evidence. So they're going to look into it and see if that's the case, and ensure that the proper standard of evidence is being used and it's being used as prescribed by the federal government. The survivor also needs to be given options, and OCR can investigate whether or not that was the case. So when it comes to a survivor reporting, they can be told what the different results of different reports may be, what these processes can look like, and maybe told whether if something's going to take a particular period of time, if it's going to be particularly difficult. However, a student should never be coerced into a certain process or out of a certain process by the institution. And they should be given a variety of different options. So they shouldn't be told, well, either you can do nothing or you can proceed with a formal grievance process. They should be told, what's in between, what supportive measures can be offered, what does an informal process look like? If they choose not to proceed with something, what does it look like for the future if they want to? So they really need to be provided with this list of options. And again, not in a manner that is coercive, though, we always want to ensure individuals know the different, consequences or results of different routes that they may take in terms of these options. The same way that we would in a survivor-led process. We're going to give them the information that they're asking, but we're going to respect the direction that we take and never attempt to coerce them in a certain way. So OCR will investigate what that looks like potentially. They also should be provided with supportive measures, right? We talk about the fact that those who experience sexual violence should always have access to supportive measures. So they may look at whether or not those were offered, if the supportive measures that were offered were adequate, if they were continuously provided, if they address the case itself, right? Because the supportive measure should really apply to the incident that happened and the individual who is looking for them. For instance, say if a student who experienced sexual violence from somebody that they work with on campus, that student should be offered changes in their campus work, not just changes to their class schedule, if that's really not what is relevant to them, right? So that there's a variety of supportive measures that are offered that are applicable to their case, and that supportive measures were not were equitable, so they weren't necessarily depending on one party or another to carry exclusively, or in a way that would deny either party access to their education. And then they also want to ensure through OCR investigations that there was not retaliation for a report being made. So say a student was not told that if they want to proceed with a formal case because they were using drugs or alcohol when it occurred, or that was a part of the narrative, that they may be held responsible under their student code of conduct. They may not be able to participate in a certain activity at the institution anymore if they want to move forward with reporting. What they essentially want to ensure is that their education continues to be accessed, and that there is nothing that would coerce them out of making a choice, and retaliation would force them out of making a choice and potentially deny aspects of their education. So no matter where somebody is, again, with the substance use, that actually is something that would no longer be legal in Connecticut due to our recent bill from the last session. But we want to kind of look at that retaliation that could have occurred and see whether or not that is something that OCR could investigate. It's also important to note when we talk about OCR investigations that this is something that can occur for either party. So this is something that students who feel as if they had their rights denied to them under Title IX may proceed with. This is also something that somebody may proceed with if they were the responding party, if certain rights were not protected by the institution. But typically, we honestly do see this pursued, especially within our capacities, but also rather generally by survivors, because historically there has been a bit more of a challenge for survivors to receive an equitable process. So this does need to be filed within 180 days of the discrimination occurring. So if, say, a student felt as if there was retaliation threatened against them, that's something that they would need to file within 180 days. They would need to put that report into OCR. However, there is an exception here. If there is a waiver that can explain why that student did not, file that information. So that's something that they can access as well. There's a waiver that they can access in the same spaces that they could access the reports that they can make to OCR. So that's something that is worth looking into if it's been more than 180 days to see if it would be eligible under that waiver. And it's essentially always worth a shot if this is something that's important to a student that's looking to file it, even if it's past that 180 days, because that waiver may be something that they're eligible for. Once they receive contact back from OCR, they need to respond within 14 days. So you want to ensure that somebody that you're working with, if they're filing with OCR, that they're providing contact information that they actively use and check, because they are going to be responding within 2 weeks. Otherwise, OCR is essentially going to drop it. So that's something they need to continue to look at. So survivors are of sexual misconduct who have these concerns about their civil rights are the parties that are going to file this. However, someone on their behalf with their written consent can also do this. We'll sometimes see this occur with individuals who are, 17 and are going through a case. Sometimes their parents will, file on their behalf or something of that nature. Typically, it is going to be the survivor themselves. However, it's also important to note that sometimes students will file OCR complaints together. So if student activists have sort of banded together and are working together, this is something that they may file on behalf of several of them. And then while an individual may not necessarily sign to that, and be involved to that same extent, they may express another student's concerns with their written consent, even if they are not necessarily one of the parties that is actively involved to the level that those writers are. And then in regards to how to report, there are a lot of different methods. So you can go through traditional snail mail and send a letter to OCR. Somebody can email a letter, or there is an online form that can be filled out. So if somebody were to look up Office of Civil Rights, Title IX, you should get that .gov landing page that would provide you with a lot of different forms of access to that report. It's also super, super important to remember here in Connecticut that the Victims' Rights Center of Connecticut Services are extremely helpful for OCR reports. This is something that they can help a survivor to draft. It's something that they can, work with them on in terms of ensuring that they're hearing back, following up, things of that nature. Once this report is filed and then they hear back, survivor responds within 14 days, there's a variety of different follow-up that may be necessary. So it's really helpful to have the help of an attorney that may be well-seasoned in this process. That is something that continues to be free and confidential and available to students in Connecticut. So this is something that they can offer assistance on, and I always highly recommend seeking that out. In terms of what information is needed, somebody would need to provide their contact information, the class that was discriminated against. So in this case, they would say that it was, they are a survivor of sexual misconduct under, that would be protected under Title IX. And that was where they experienced the discrimination, right, was with that identity, the name and the location of the institution where their rights were discriminated against, and then the description of the discriminatory acts in sufficient detail. So what had occurred, when did it happen, where did it happen, so that OCR can follow up accordingly to let them know whether or not this is eligible and what next steps will look like. So, do you have questions? Because there could be plenty of questions to be asked. So if you do have questions about this, there are different places you can turn to for help. So you can contact me, and there's me. I'm delightful. I'm always here to provide help That's me drinking apple cider with my small dog. So I'm somebody who is really accessible and helpful and nice. So please talk to me. I am more than happy to help you. And I will also show you pictures of my cute dog if it will help you in your self-care journey. You can also contact the Victims' Rights Center of Connecticut, even if somebody isn't going to necessarily be proceeding with an appeal, an OCR complaint, or another method of follow-up. For a case, they can provide the list of different options and what those could look like, the list of different supports they can provide depending on the option that somebody proceeds with. So if VRCCT isn't already involved in a case, if you feel as if a student's rights were not protected adequately through a case, they can provide more information. Or you can contact the officer on civil rights themselves. So you can actually contact OCR directly, and they provide technical assistance for these cases. So you can send them an email and they actually could get back to you if you have questions. So there are lots of different resources that you can turn to. So what's next? So next week, actually it'll be week 4, a little typo there. My apologies, but week 4 will be on April 8th. That is correct. And we'll be talking about Connecticut's campus legislation. So in addition to all of these federal rights, what does it look like for Connecticut students, and what additional protections do they have in place? What additional responsibilities do their institutions have to protect them? And what role do our campus advocates have? Where do they sort of have a right to be involved? And how do students have a right to have a relationship with them under Connecticut's legislation? So we're going to be doing that April 8th, which is next Friday at 10 a.m. Once again, please bring your warm, or in this case, cold beverages to caffeinate with, or decaf if that's your vibe. And these will continue to be posted on Monday mornings on the Alliance's social media. Also, in response to concerns about Good Friday, we want to ensure that everybody continues to have access to these presentations live. So we are going to be taking a brief break on April 15th to acknowledge Good Friday and the folks that may be off for Good Friday or recognizing Good Friday. And then we'll be resuming the following Friday after that. Additionally, next Friday, April 1st, we will not be having a session either because we will be hosting the Alliance's Child Sexual Assault Prevention Roundtable program, which is our kickoff to Sexual Assault Awareness Month. So please contact me if you have more questions about that, because I am planning that program as well. But I will leave you with all of that. Thank you so much for learning more about this with me today, and have a good one.